Hello, I'm Ashely Strauss-Martin, General Counsel for the Realtors Association of New Mexico, and I'm here today to talk about two new laws that will impact broker that take effect July 1st, 2013. The first is a brand new law called the Homeowners Association Act, and as the title suggests, it deals specifically with how homeowners associations are governed and requirements of homeowners associations. The second is an amendment to the existing law, the Public Improvement District Act, and it has specific seller disclosure requirements that will have a great impact on sellers and sellers' brokers. The Homeowners Association Act covers all homeowners associations formed after July 1st, 2013, and all but a few sections of the Act cover existing homeowners associations. The Act does not apply to condominiums that are already governed by the Condominium Act. Under the Act, a homeowners association, or an HOA, is defined as an incorporated or unincorporated entity upon which maintenance and operational responsibilities for common areas, easements, or portions of right-of-ways are imposed, and to which authority is granted to impose on lot owners or occupants of those lots any mandatory payments to be used for maintenance or services for the benefit of some or all of the lots, the owner or occupants of the lots, or the common areas. Under the Act, the HOA may only consist of lot owners in the development. Now, the Act requires HOAs organized prior to July 1st, 2013 to record a notice with the county clerk's office in the county in which the property is located by June 30th, 2014. An HOA organized after July 1st, 2013 must record a notice of the HOA with the county clerk's office no more than 30 days after the date on which the HOA's declaration is recorded. The Act sets forth the specific requirements of the notice. The significance of the notice is if the HOA fails to record the notice in the time frame provided under the Act, the HOA is prohibited from charging any assessment, levy, fine, or late payments of an assessment, or from enforcing a lien for non-payment of assessments until such time as the HOA records the notice as required by the Act. The Act also addresses declarant control of the HOA. The Act defines the term declarant and dictates that regardless of the period provided in the declaration of the HOA, control of the HOA will transfer from the declarant to the property owners upon the earliest of several events as set forth in the Act. The Act also outlines additional provisions governing declarant control of the HOA. The Act allows HOAs to lien property and provides that HOAs will have a lien on a property for any assessment levied against that property or for fines imposed against that property owner, and requires that upon written request by a property owner, the HOA must furnish the property owner with a recordable statement setting forth the amount of unpaid assessments against the owner's property within 10 business days after receipt of the request. Additionally, upon written request by a property owner, an HOA must make all financial and other records of the HOA available for examination by the property owner within 10 business days of the request. An HOA may not charge a fee for making financial and other records available for review. However, it may charge a reasonable fee for copies. What constitutes financial and other records is defined under the Act. The Act requires the HOA to adopt an annual budget and dictates when an HOA must conduct a financial audit. An HOA must provide the annual budget to the property owners within 30 calendar days from adoption. For HOAs formed after July 1st, 2013, there are provisions requiring that a development with 100 or more lots conduct an annual financial audit, review, or compilation of the HOA. And for HOAs with less than 100 lots, that upon a majority vote of all the lot owners that such audit, review, or compilation be done. The HOA must make the audit, review, or compilation available upon request to the members within 30 days after its completion. The Act also addresses voting and attorney fees. For HOAs organized after July 1st, 2013, the Act sets forth when and how proxy and absentee voting shall occur and provides that a court may award attorney fees and costs to any party that prevails in a civil action between a property owner and the HOA or declarant. But the most important aspect of the Act for brokers requires sellers to make certain disclosures to a buyer before closing. Under the Act, the seller must provide the potential buyer with the following documents prior to the closing date: the declaration of the HOA, the bylaws of the HOA, the covenants, conditions, and restrictions applicable to the property, and the rules of the HOA. In addition, no later than 7 days prior to closing, the seller must provide the buyer with a disclosure certificate from the HOA. The disclosure certificate must include the following: a statement disclosing the existence and terms of any right of first refusal or other restraint on the free alienability of the property, a statement setting forth the amount of the monthly common expense assessment and any unpaid common expense or special assessment currently due and payable from the selling property owner, a statement of any other fees payable by property owners, a statement of any capital expenditure anticipated by the HOA and approved by the board for the current fiscal year and the next 2 succeeding fiscal years, a statement of the amount of any reserves or capital expenditures and of any portions of those reserves designated by the HOA for any approved projects, the most recent regularly prepared balance sheet and income and expense statement, if any, of the HOA, the current operating budget of the HOA, a statement of any unsatisfied judgments or pending suits against the HOA, and the status of any pending suits material to the HOA of which the HOA has actual knowledge, a statement describing any insurance coverage provided for the benefit of property owners and the board of the HOA, a statement of the remaining term of any leasehold estate affecting the HOA and the provisions governing any extension or renewal thereof, and the contact person and contact information for the HOA. Upon written request by a property owner, the HOA must provide the disclosure certificate within 10 business days. The Act provides that a property owner is not liable to a buyer for failure or delay of the HOA to provide the disclosure certificate in a timely manner, or for any erroneous information provided by the HOA and included in the disclosure certificate. A disclosure certificate is not required in the case of a disposition pursuant to a court order, by a government or governmental agency, by a foreclosure or deed in lieu of foreclosure, or on a contract that may be canceled at any time and for any reason by the purchaser without penalty. Upon receiving the disclosure certificate, a purchaser has 7 days to cancel the purchase agreement. If the purchaser cancels the purchase agreement, the seller must refund any fees and/or earnest money paid by the buyer within 15 days of cancellation. Random has created an HOA information sheet, an HOA addendum, and an HOA disclosure certificate to provide to the HOA, and these forms will be available in zip form by July 1st, 2013. If you have any questions about this form, please contact the Random Legal Hotline at 877-699-7266 or in Albuquerque 821-1583, or email us at this legalhotline@nmrealtor.com.